Welcome to Third Fridays, the monthly legal talk show from LOIS LLC featuring attorney Christian Seeson. This is the original forum in which real attorneys discuss workers' compensation issues, share their opinions, and engage in colorful conversations. This show showcases diverse perspectives of attorneys handling workers' comp cases, including case law trends, practical litigation strategies, and hot topics. Here's your host, Christian Seeson. Are we recording now?
We're recording now.
I've been looking forward to this for so long. Thank you for having me on. Thank you.
If you guys can't recognize that voice,
So glad to be here. I can't tell you. When was the last time I was on this podcast?
it was a long time ago. I think you've only had like one or two.
Like years. Because you've been doing this now since 2017?
2016, I think.
2016. 8 years.
Yeah.
And we can't even think of the one time that you ever let me appear.
This podcast is almost as old as your kids.
Wow. Yes. That's crazy.
Right?
And again, you do 12 a year,
Right.
towards 12 Third Fridays a year. So you're thinking
Right.
96 opportunities.
Right, to ask
but
Greg LOIS.
Never asked me.
Yeah. You ever watch, I don't know if you watch Jimmy Kimmel, the late night
Sure.
host.
Yeah.
He keeps leaving room for Matt Damon to come on at the end of the show and then never has time.
Oh, so I'm your Matt Damon.
Right. The bigger star.
So you're saying I
have
look
the
more
show.
like Jimmy Kimmel though, and yeah,
Oh, you're going to say I'm a Matt Damon?
Yeah.
Potentially?
Yeah.
Okay. Well, if anybody hasn't recognized that voice already, it's the one, the only Greg LOIS on the show today. And if you think we're going to talk about, your garden variety appellate division case today, you thought wrong. Being on the cutting edge of workers' compensation and employment defense has been as the archetype of this company since it began in 2015, which makes sense because we're going to be celebrating our 9-year anniversary
next week. Well, the day this podcast drops.
When you hear this, we have already celebrated.
Yep. And you'll have announced the winners of the 2024 mock trial competition.
The 2024 mock trial winners will have been announced. So if you guys listened to last month's episode, you would have heard all the finalists. And so we had a great rendition of trivia. We had an oral argument on appeal. We had some exposure evaluation, given that the training topic of the month was Medicare. We talked about all the compliance and future medical cost issues last month, which was, to us is very exciting. And yeah, that's always another mark of another year with 2 people being crowned, 3 people this year being crowned champions.
Yeah, and does your audience know about the third category that you started this year?
They do because all 3 our delightful director of branding just compiled all of their podcast recordings into one episode last month.
Boy, that was
Right.
probably a lot of work.
So mentors, attorney litigators, and paralegal litigators, we have 7 finalists going up for the top prize in each of their categories. So that's going to be an exciting thing to announce.
Yeah, that's
from
really cool.
next week.
Yeah, so I'll have 3 winners this season, and one of that categories we've never had before.
Right.
So
We've
that's-
never had a competition for experienced attorneys or paralegals basically game planning
yeah,
a trial.
mentoring the other
Right.
crew through it. So
Mentors.
I guess, are you going to give us an amuse-bouche or a little hint from the chef, a little, just a teaser about it? Do you want to give me any hints,
I
or
guess-
should we just keep the?
I guess in theory, the finalists wouldn't hear this until the day of.
Oh, you got to be careful though, because he
right.
posts it before.
He posted
we
at
have the
midnight,
meeting.
right?
Yeah.
So that if I would put my finger on a couple of them, just waking up to the podcast, right? Like that's
Absolutely.
their alarm,
Yeah.
right? They
Well,
love
I
this
get
so
a
much.
notification on my phone when you drop a new podcast with a little blurb about what's in it. So we have to be very cautious about this. You know what?
Yeah.
Just to protect the surprise and, keep everyone on the edge of their seats. Maybe that's something for you to announce next month.
That's a good idea. That's a good idea. Well,
I am excited though. I mean, I cannot tell you, I think this was a great season. You had great participation and
the most ever.
yeah, and a new format too. So just to see the mock trial evolve year after year after year and see, and it's a revolving cast too, which I like a lot. You have really inexperienced people, you've got somewhat experienced people, and now you're trying to really utilize the most experienced people as mentors. So there's every skill level. I've heard so many people say things like, hey, this is an opportunity to meet people throughout the whole firm,
right?
And get to know people in other groups that they never would work with. So I just think it's just such a cool thing. And well, kudos to you for starting it.
We also had a new wrinkle this year as well last month, where we had each of the finalists come up with a new idea for next year. And I said that I would pick one idea to actually implement next year.
Oh boy, I'm sure it's going to be like a bigger prize, or
right?
Pizza Wednesdays, or
playing with the firm's money.
Yeah, I mean, come on, it's great. It's great. I just think the energy around it is just great, and the amount of excitement. So awesome! I can't wait to find out next week. Who prevails and who wins, and we'll be able to celebrate it because it is our 9th anniversary. We have our anniversary party next week, and that always is a great celebration for everyone. So.
Right. I do like that the beloved employee experience team here has also kept the winners away from you, right?
I have no idea.
Even you
I have no idea.
Know who is going to win.
I'm sure every year you give them a plaque with a gavel on it.
Right.
So I'm sure that's already been ordered.
We already have it, right? No. So
okay, here's another one for our anniversary party. Every year there's a different theme,
right?
Our 7th-year anniversary was Lucky
Sevens Casino.
We had a casino night.
Yeah,
and I have no idea even what the theme is for the party. It's totally a surprise to me. So
right,
they keep you in the dark about a lot of stuff.
Last year you kind of knew because that was the opening of LOIS Lab.
Oh, that's right.
Celebrate, right, for 8. This year, again, back to it being in the dark. Honestly, that's probably better for you.
It's better. Yeah. I like to be surprised too. Come on.
Yeah.
But we didn't. I mean, look, we have a great topic. I think it's an interesting topic for today's podcast. And of course, because I'm going to say that because I get to be on the podcast.
Big surprise,
I'm so excited. I can't tell you what a thrill. I listen to this podcast when on Friday mornings when it goes on. I look at my phone, I turn my phone over, and it's the first notification. I'm like, all right.
Yeah, you're going to get jazzed in a week when you see your own name.
I really am.
As a notification.
Unless they say something stupid, I regret. But maybe John Grayson will edit that out for us. But we're in a new studio. Right?
Brand new.
And that's something that we built out after we finished LOIS Lab. And today's topic is about technology, and particularly as it impacts workers' compensation claims.
Right.
And we want to talk a little bit about some medical stuff that's developing and, just kind of.
Who better than you?
Just putting on our creativity hat a little bit and just kind of thinking about that. But, one thing I did want to mention, because I never get on this podcast, so I'm going to use this opportunity to say how much innovative stuff just in the last year alone that we've tried, that we've deployed, right? And so I do want to mention a couple things that I think are exciting and different. So one thing that we've always been about metrics here. And
absolutely.
When you go on our firm's website page, it says stuff like, hey, we're a metrics-driven defense. And that's just because at the volume we're operating at, when we're taking in hundreds and hundreds of new claims every single month, and at the volume we're working at, we really have this opportunity to look at this incredibly large case population and run metrics against it, which we've been doing since 2018. And we were sort of early to that party. In 2018, we moved our technology platform to a platform that was SQL-based, which allows us to run SQL queries and use things like Power BI to interrogate our data and come up with, interesting ways of graphing or looking at our data and trying to look for correlations. And we've been really early to that party. And, a couple of years ago, we got involved with the Gallagher-Bassett pilot of Gallagher-Bassett Legal Score, which some of our clients might be familiar with. If you've
ever received an email from us recently.
Right. Well, yeah, if you use them as a TPA, they are running a pretty remarkable analytics system on their side that we piloted with them. And we were like early adopter of that. And we've been giving them feedback, and we meet with them on a regular basis to give them feedback about when we look at that data. Their system, though, only looks at closed claims. Our system looks at live, open and closed claims, right? Because I want to see how we're performing day by day and week by week and month by month. And certainly, those predictives that we can look at, we're going to want to see those from a leadership point of view, what's happening. They only look at closed claims. I'm very proud to say that when we look at their system, we've been rated gold or in the top tercile because they do it in 3 terciles. You're either great, you're okay, or you're bad, right? We've never been bad. Right. We've always been in that top tercile. We used to publish that in our emails and, publish that more frequently. But, we're really starting to see the metrics and the analytics being utilized more and really seeing everybody sort of catch up to that. But that was a thing that we were early to the party. I actually just met with Gallagher Bassett this week, their legal score team over there, looking at the analytics and, really trying to learn how to drill into more of their system, take a look at how they're ranking and rating, the objective and subjective factors. But when you walk around this firm, you see dashboards up on the walls. I mean, everybody who works here can see that. And when we built out this LOIS lab facility that we're in now, we still have those same dashboards and metrics running through this facility as well, which is really great, I think, for letting people kind of know where we're at, where we are. So I think we've always been a little early on some of the most provocative or transgressive or most interesting tech stuff that's happening. Most recently everything's been about AI, been crazy AI. And obviously Paolo is our director of IT. We've dove into that really early, really quick.
You gave a speech, you gave a presentation on AI.
In June for the New York Self-Insured Association. Right. Yeah. And it was interesting because I actually said in that, I put up a live poll while I gave the presentation, and I said, all right, it's all industry people, and there's a lot of law firms that were there as well. And I said, okay, raise your hand if you're using AI right now in your practice. And, they hit the poll, it had a QR code and they could click the QR code. And, more than half the industry that particularly on the claim side, insurance side, they're really deep into it and how much, what are you using AI for? And we did a little bit of that. And then I said, attorneys, okay, law firms, feel comfortable, here's a QR code, tell us if you're using it or not.
Way lower. About,
1 in 5, 1 in 6 was saying that they were using AI. And then I said, all right, now, do you have any restrictions on AI? Like, do you have any idea if the people inside your practice are using AI, right? Because it's built into Windows 11. If you're using a Windows desktop, it's just showing up in your Edge browser. It's showing up as an app. I mean, do you even know?
You have to actively prohibit it.
That's right. Yeah. I mean, we had to disable all of those calls inside the system so it couldn't get out. And the answer was they didn't know, And so some of this technology, as it's, progressing, and it's going to become more and more necessary for us to be efficient and to utilize it effectively. I mean, there's no way we're going to, at some point, have to figure out ways to harness it and make it useful so we can deliver legal service at a really good price, but also make sure that there's enough judgment and responsibility there and it's being done correctly. But so to me, that's one of those things that's emerging. I don't think it's going to be disruptive at all because every single competitor in the market, every single law firm is going to deploy it. I mean, there's no barrier really, right? I mean, you can go out and sign up right now for a ChatGPT or a Grok account, and you could just do it right now, right? So,
live with AI before AI passes you by.
Right. No one's gonna own it. So it's not gonna be one competitive law firm has AI, but nobody else does. We're all gonna have access to the same exact tool. It really is. The question around it now for me is all about security. I am convinced it could be productive for us. I'm convinced it could be efficient for clients. I'm convinced that it can do amazing things. I was building a model. I was telling you about this. I was building a model to project our costs of training for our attorneys, right? We onboard people in groups and we're projecting out our costs of trainings. And then, when you start trying to account for attrition and drop off and all those things, the model gets really complicated. And I just went right to ChatGPT and I said, I need you to help me write some of these Excel formulas. And it did. And it did a great job. And, then I said, okay, now let's validate those, right? So does a lot of things that I think are going to be pretty useful for us and useful for our clients. But all the questions I have about it right now are about security. So when we tinker with AI and we're testing it, and right now I got AI writing IME cover letters, and it's doing medical summaries, on our test system. We're using isolated systems away from our production systems. And our systems here, nothing touches the cloud. There is no cloud. In fact, when we opened our second office in Manhattan, we have a dedicated piece of fiber. We run fiber to that office. So we have dedicated fiber so that when you're in that office, actually you're part of our local net. You're not going through the cloud to get to the other office, right? So, we take that stuff very seriously. And I think that's where all of the issues are gonna arise. People are concerned about AI's wrong a lot, and there's no confidence interval in AI. It'll give you an answer, and it'll seem like it's the right answer, but it doesn't tell you, oh, by the way, I'm not sure if this is the right answer. It can't do that.
Right.
There's no opportunity for it to tell you, hey, I'm telling you this is an answer, and I think I'm 80% sure this is the right answer. It'll give you the wrong answer and be very confident with that wrong answer. So people are focusing on those things. But I think people need to focus on the issues around security, and particularly data security.
It's almost as if the wrong answer idea of AI is just public, like people believe that's the thing, but it actually doesn't make any sense, because if you're going to use AI as legal professionals, we're responsible for still verifying everything. If we're going to use AI to provide reports and work product to clients or to the courts, we still have to go through it as humans to figure it out whether that's true or not. So even if AI, that was the biggest problem, that would be a good thing, because we would have no other exponential costs to that. We're going to have exponential costs with verifying security. So almost like being a first mover there.
Well, the only way we're going to do it here is if we can run it on-prem. And they're already starting to show large language models that you can deploy locally and train against your own data and never expose it to the internet. Right now, when I go to Grok and I ask it a question, or I say, make a funny picture of Elon Musk dancing, it's that query itself is shared, and it's not my data anymore. So my concern is that when you're submitting data to these engines, to these tools, the data you're submitting is not yours anymore. It's on someone else's server. They have access to it, and they're using your questions to teach the model. So you got some real concerns about that. The questions you're asking it become the fundus of its knowledge going forward.
You're adding to the base.
That's exactly right. And things like go through all these medical records and give me an opinion. Well, it's looking at someone's medical history, their social security number, their date of birth, and that's all getting submitted through the cloud to some engine that you don't understand, processed, becomes part of the fundus of knowledge for that piece of equipment, and then it returns you some result that
you don't think claimants are going to give you HIPAA releases to go to the cloud?
No, absolutely not. I mean, I wouldn't even know what I'd be asking them to release it to. I mean, where is
Who's
the data?
entity?
Who owns it? When all these questions are to be resolved before it can become a productive tool. And I'm really leery of what I've seen so far. So, for example, there are now we have a document calendaring, case and billing management system here that's homegrown and that does all those things. But there's lots of competitive products out there, and a lot of them are based in the cloud, right? So that's one level of insecurity that we don't anticipate. But those products are now advertising, your practice management software suppliers, that they are integrating AI into those products already. So your Clio, your big things like Litify, they're advertising on their front page, hey, by the way, we've integrated AI features into this practice management software, and to me, it's a nightmare. I mean, first, you're already putting your data in the cloud, so it's, in my opinion, subject to some issues there. But now you're also telling it, and we're also then submitting your data to these large language models for them to run queries against. I mean, that's a nightmare. So that's the stuff that I'm trying to bring to my clients' attention. So as clients talk about hey, can we get some efficiencies with AI? What are you guys doing with it? I say, well, let's look at some of the security issues and downfalls and maybe loss of confidentiality and privilege that could occur. So, we got to be really thoughtful about that stuff. And those are the kinds of things that are, we're looking at, from the big picture. The other stuff that we did this year that I just went on and mentioned, because I think it's really unique and interesting, is this year we spooled up and staffed an auditing department, a self-auditing department, which I think is going to be a huge differentiator. It's one thing to talk about how our clients and some of their administrators rank us, right? Like we know
just got
Sedgwick.
to talk about the TPAs ranking us.
Right, Gallagher Bassett, the legal score program. So we're doing that internally now. And we have spooled up an auditing department, which is going through our matters. They've been through about 1,000 of them so far. So we're starting to create a pretty robust data set in there and start to develop the skills to do that. And in that department, we've created a new role called Client Compliance Coordinator, who's going to help make sure that the work we're producing meets client expectations. And we're talking about more than just litigation management guidelines.
Right.
So, Yeah, I'm very excited about that. That's a place where we're going to probably put a lot more investment over the next year or so, and really do I think a class-leading, industry-leading job of really taking a hard look at our own matters and saying, are we handling these cases according to our own standards? Right?
Because if we beat our own standards, it will pass everyone else's standards.
Yeah, absolutely. I mean, we have always been ahead of the curve on that. In fact, when we get ratings from our TPAs or carriers, we always are way ahead of the curve in terms of service promptness, reliability, the quality of work, the subjective ratings, right? But we're really trying to turn that into an objective rating system, some data points that we can really rely on. So I think that's been a huge endeavor, and staffing it has not been without cost, right? As we start to build that out. And so I think that's what I'm going to be talking about next year. I think that internal auditing, becoming a real game changer, and doing that in a way that nobody else is doing that.
Well,
Nobody
speaking
else
of
is
game
investing in
changers,
that. Yeah.
right? When you proposed this idea, I almost thought, well, this, new medical technology, new medical advancements, when does workers' compensation get to use them, right? So you proposed talking about two things, Neuralink, which is, type of these coin-sized implants that Elon Musk is using to implant in people's brains who have severe disabilities, paralysis from the neck down. And we also were discussing, 3D printing of implants for, giving people a new face, a whole eye being implanted into someone, using 3D models to shape a donor bone into for an eye to be placed in someone's face. And I my immediate thought is, we don't see this in workers' compensation now. When are we going to see it? Not for a while, because there are costs. But I'll maybe give it to you. What touched on you to think of this being relevant to workers' compensation?
Well, I just thought it was an interesting sort of thought experiment when you think about the law, and let's talk about in New York, right? So New York workers' compensation law, there is a definition of disability. It's medical impairment plus vocational factors, essentially, and it's relatively, stable. New York has a wage loss theory plus an impairment theory of compensation. It's kind of a hybrid state in that regard. New Jersey is the other state that we practice in predominantly, and New Jersey has a completely different theory of workers' compensation, which is it's an impairment theory. It's called the whole man theory, and that's what they called it 100 years ago when the workers' compensation law was established. But the idea in New Jersey is you're getting compensated not for your wage impairment or your lack of wage earning ability, but just simply for the injury itself. That the injury itself and the change to the definition is really the change or impairment of any structure or system of the body. That in and by itself is what's compensable. And so most states have some version of one of these two, either a wage loss theory or an impairment theory of workers' compensation. And so it's interesting that, sometimes the more treatment we see in our workers' compensation cases, the higher the permanent residual disability exposure, right? I mean, and it's because, obviously this is the workers' comp context, treatment that's very successful outside of the workers' compensation context. As soon as you put in that overlay of secondary gain, all of a sudden, the shoulder surgeries leave you more impaired than you were before you had the shoulder surgery, or knee arthroscopy, which, I've had meniscal repairs. I don't know if you have or not, but, by the time you're my age, you may well have that happen to you. But I mean, these are really safe procedures that, really do restore function and reduce pain, go right back to running or tennis or whatever in the general population. But then in the workers' compensation population,
makes you worse.
A meniscal repair actually worsens you. Your condition, you actually get a bonus in the scheduled loss of use chart for actually
Claimants'
getting
attorneys are cheering when they're ready for surgery.
And there's that other avenue, aspect of medical care in this context, which is more medical care earns the claimant a larger award and their attorney more money, right? So you get into the system where all these negative incentives are at play. And I can also say that there's a prevalence in the system of, they're permanently totally disabled, write them off. That it is what it is, and let's issue the award. It's over, right? Now, I think this is a great conversation to have right at the end of the Paralympics, where you see people overcome
great point.
Tremendous disability and they're doing activities and performing at a level that, most able-bodied people or non-injured people or non-impaired people would wish they could perform at those rates, or those abilities. And, you just this month, right? We're doing a fundraiser here, and you can go on our website if you're listening to this and it's still the month of September, raising money for the Challenged Athletes Foundation. We believe in that stuff. We believe in overcoming disability. The system doesn't. The system is, there are requirements in our system for vocational rehabilitation. Does anybody ever do it? No. Does any judge ever order it? Is there really any attempt to mitigate or to reduce or try to deal with or move past these impairments? No, because you're getting money based on these impairments. Why would you ever try to overcome them? And that's the negative incentive built into the entire system. And again, we're not talking about the typical workers' compensation claimant. 85 to 90% of people get injured at work, get medical care, come back to work. That's it, right? We're talking about the kind of cases that you and I defend. We're
not on those easy ones.
Yeah, and I've never seen those cases. I only see the 10 or 15% of cases where there's gamesmanship going on and they're manipulating the system. And it's these, a sprained ankle turns into a 4-year-long odyssey of out of work notes. It's just nonsense. That's what we see. So, I am coming at this from the perspective of, I'm here to protect employers. I'm here to protect employment, right? And so that's my perspective. But, when we start to think about, hey, what kind of goal system would we really want? We'd really want a system that encourages people to try to overcome these impairments and, encourages them to try to become productive. I believe personally that work itself is dignifying. We're meant to work, read Genesis chapter 3, God, they made the Garden of Eden and Adam was put in there to work the Garden of Eden. That was, it wasn't there to lay about and eat grapes all day, right? So there's something I think dignifying about work. And that's the part of my job that I connect to, that I want to be a part. I want to help make sure that employers can keep their businesses open and employ people. I think it's an important thing.
It makes the world go round. Protecting the integrity of employment has always been, what we do here, right? I think that maybe there is, an unfair black cloud sometimes on defense attorneys. It's like, you're the bad guys, you represent
black hats,
the big bad companies. But in reality, and it's what I say to people all the time, like, we don't see those claims where it's a legitimate injury and the person comes back to work because that's a normal person, right? We see the abnormals of the world trying to make a work accident their retirement package.
Yeah, absolutely. It's they think it's a mislabeled retirement system. It's not a workers' compensation system, right? And the other thing that we have to be thoughtful of, now let's take off we're here to protect employers. Aren't we also here to protect the general public? Because I think what happens is in these workers' comp cases, you get more money for getting more care. So guess what? The claimant goes to the doctor once a week. They're getting MRIs they don't need. They're getting all sorts of care that's unnecessary. You're going chiropractic, physical therapy for years. It's
just to build a case. Just
to stay out of work. And they're consuming medical care that maybe someone else needs to get, someone who's legitimately injured. If you ever wonder, you go to schedule an MRI and they tell you it's going to take 3 days to get into the MRI facility. Well, it's because these people that are playing the games with the system are clogging up the system with all this nonsense.
Or doctors and providers that only do workers' compensation, which is interesting, right? Like they are the pushers of the paper that create these cases. You're right. There's a backlog of it. It goes all the way down to, being in a waiting room for too long, right?
Sure. All of that stuff. So we really start to dive into what does it really mean when we're rewarding people to stay out of work and to seek maybe unnecessary care? Well, what are all the knock-on effects? And we're just starting to touch on them, right? One of them is obviously the effect on the employer, but what about the whole medical system as a whole, right? Someone's got to speak up for that and protect that. So I'll get off my high horse now, but so in that context, I keep thinking about, hey, medical treatment is advancing, right? It's getting better all the time. They're coming out with these breakthroughs. Things are changing. In my family, in April, my mom had a heart condition. She went to the hospital in May. They did a 2-level valve replacement. It was unbelievable. The amount of care, the attention, the high-tech care that she received, unbelievable. They stop your heart, right? They cut holes in it. They put in new valves, and then they turn your heart back on. The whole thing, it's unbelievable. And we've all probably been wowed, right, by some of this stuff. But
So when does it impact our cases? And, the kinds of injuries we see are generally not, cardiovascular incidents, right?
Sure.
Or cerebrovascular incidents. What we're seeing is orthopedic injuries, and the spinal injuries, neurosurgical injuries, and then, the most significant class of injuries, those that would lead to permanent total disability. And we're talking about things like blindness or loss of limbs, amputation, quadriplegia, paraplegia, that stuff that is really huge exposure and sad. I mean, there's nothing sadder than a 30-year-old double amputee, or a 30-year-old who's lost their vision, and now they've got a long life ahead of them that's going to be very impaired. And so when I was looking at some of this stuff, and I'm just exploring it, is the new medical treatment that's coming down the road, and then I was starting to think, oh, what kind of impact would that have on workers' compensation? And the two things that kind of stuck out to me, and this is where our conversation kind of came from, was Neuralink's trying to reverse someone who has a complete neck down quadriplegia, right? And they're getting, he's now able to manipulate objects just using his thoughts.
They have him playing like chess against the computer.
It's unbelievable, right? So these things that are maybe are going to emerge, and then I start to think, well, what if that guy was a workers' comp claimant? Right? What if he was, and he was collecting perm total, and now Neuralink fixed him up, and now he can do things, and he's productive. He's not totally disabled anymore. What would happen? Right?
We want to reopen that case.
Well, we'd want to reopen the case. So the first thing is, I'm like, could we appeal? No, you're way out of time to appeal that medical determination. But New York does have a backdoor, and that backdoor is Section 123, which says the board has continuing jurisdiction, or the court has continuing jurisdiction over a workers' compensation case for up to 7 years. They can reopen the case because the facts have changed, right?
Basically used as almost as catch-all when the procedural requirements haven't been met sometimes. Section 123 is kind of used almost as a weapon sometimes by the board. Yeah. But, you're right. Like, if a perm total has already been found, the appeal timelines have been exhausted, here comes this medical development, technology is advancing. Of course they have that opportunity.
Yeah, and what a great thing too. And then I started to think, all right, well, isn't this good? I mean, I'm sure the Neuralink cost is going to be astronomical, literally. Right. I mean, it's the billionaires funding this thing to get it to go, and they've only treated, I think, 30 people so far.
I don't think they have that in the fee schedule.
Right. It's definitely not in a medical fee schedule, I can tell you that. And then the other innovation that was last week was they did the first successful eye transplant. Eye transplant, not just a cornea transplant, which has been going on for 20, 30 years, but an eye transplant. A whole eye can reconnect an optic nerve. I mean, that's incredibly complicated neurosurgical procedure.
So it's having its own blood supply too. Once it's in the man's face, it's incredible. I mean, his daughter even gave it 100 out of 10 on TikTok. So.
Wow. All right. So just an amazing thing to think about, and then to start to think, well, I'm sure the costs of that are astronomical right now, and I'm sure they are. But Section 123 might actually provide an incentive for an insurance carrier to actually do it, because if you could reverse a perm total, if you could, first, if you can restore the person's dignity and their ability to carry on their activities of daily living, that's amazing, right? Like we should do that. But when you and I initially talked about this, we said, but what about the massive cost factor involved here? And you're right, it would never be subject to a fee schedule because it just is way too soon. I mean, the fee schedule really is no provision for this at all. So how costly would this be? But then I think the answer to that is, but it could offset the other costs in the case, because under Section 123, you could reopen the case and say, you know what, he's not total anymore. He's partially, and maybe that's the incentive, if that, particularly in a young claimant, for the carrier to really go above and beyond and try to find some really advanced technological solution to maybe this impairment condition.
Not to mention the costs are diverging oppositely, right? Indemnity has always gone up, right? They raised the minimum rate in New York for the first time in 11 years this year. It's going to go up again next year.
And every year thereafter.
Probably. The statutory maximum rate has gone up every year. And medical costs, even though Neuralink and a 3D printed eye implant is not going to be cost effective now, costs in medical technology will go down.
Yeah,
right?
Absolutely.
The better that they become, the more trials that are run. If the FDA is approving Neuralink from a trial perspective, of course, it's not even going to be available to the general public. But once it becomes available to the public, it's just going to get cheaper and cheaper and be affordable for workers' compensation carriers.
Yeah. So I just, all this stuff that's happening out there, and, again, we're trying to always apply it to what we love, workers' compensation, right? We love it.
Yeah.
We love it. We love it.
Live it, breathe it.
It's just interesting. So we'll see how these medical advancements start to develop and how the incentives might change, and particularly in these very high exposure cases. That's where I think we'll see it first. And then, just kind of watch how this develops. But look, I can't tell you how excited I've been to be part of this podcast. I mean,
well, if everybody listening heard Greg talk about our latest LOIS Love initiative, he did mention that we benefit the Challenge Athletes Fund, who we've had a great partnership over the last few years with. Our current initiative, if anybody wants to do their Christmas shopping a little bit early,
oh yeah,
right? Even get it done before the Black Friday rush. You can get all the snazzy LOIS merch that we wear constantly, and the firm is going to match that cost in a donation to the Challenged Athletes Fund. The Challenged Athletes Fund is a great company that really provides resources and tools to disabled individuals who want to participate in sports, who want to participate in just other areas of life that they have not been able to, such as education and things like that. It's been a great source of I guess happiness, honestly.
Yeah, no, I find them inspiring because they support not just people with acquired disability or acquired impairment, but also congenital impairment. So when you go to an event and you see athletes who have really overcome a lot, I think it's a great perspective, and just they're a joy to work with. If you're out there thinking about a charity that you might want to get involved with or get your organization involved with, this podcast I think is probably listened to by a lot of employers and a lot of carriers. What a great organization. They've just been an absolute pleasure over the last few years to get to know them and get to support them. So, we have something going on this month. We try to visit with them at least once a year and do an event with them every year. And this month, what we're doing is matching purchases of merchandise, really cool shirts and hats and stuff. So if you want to go to our website, check that out. And I know that link's going to come down at the end of September. So if you're listening to this, do it soon.
Well, for Greg LOIS, the one and only, my name is Christian Cisan, reminding you to defend from day one.